Good afternoon, everyone. Good afternoon, and welcome to this Zoom meeting, one of many that's been dealing with the meetings that have been dealing with issues pertaining to COVID, but not just COVID, many other issues that are pertaining to our public affairs and religious liberties. I just want to invite every single one of you, and I want to thank each and every one of you that's made it here on time. Now, without much further ado, I just want to quickly, before I go into introducing the speakers, I just want to go through some housekeeping rules. Just to let you know that, first of all, that we are the Zoom chat, or the Zoom chat is not going to be open until just before the Q&A section. That is because we don't want people to be distracted, and we certainly want our presenters to be focused on the issues that they're presenting on. So please do not try to put anything in the Zoom chat before, until it's actually open. Just to also let you know that we would like all who are, if you do want to hear more and to find out more information regarding future meetings, etc., then please do leave your email in the chat, and we'll get in touch with you. We've also got a YouTube channel that is streaming this meeting right now. I believe that link should be in the chat room at the moment. Yes, it is. So if you do know anybody else who is possibly struggling to get into the meeting, then do send them that Zoom link. It's the first information that's appeared in the Zoom chat at the moment. Furthermore, I also want to let you know that we, at the end of the meeting, there will be music that will be played, an outro type of music. You have the intro, but you will also have the outro. So once we finish the prayers, then that music will begin to play, and there'll be a screen that will appear to thank you for attending the meeting. And at that point, please do begin to log out of the meeting. So as soon as we finish the prayer, you'll see that, and there'll be some music that'll be playing in the background. That'll be your cue to let you know that it's time to now log out of the meeting. So without much further ado, I just want to introduce our speakers for today. Ladies first, as we all know that they are very important to us. And we have a guest speaker today, Sister Ayomi Soremekun. Now, she is an accomplished HR consultant, and she's going to come up with some very important information for us. So I urge you to pay specific attention to what she says. And it's as you can see, the presentation, the meeting presentation, the title is UK COVID-19 Vaccine and Your Employment Rights at Work, something that is obviously very, very important to us. And along with her, we're going to have Pastor Kavaloh, who's been presenting and is the one who's enabled this platform provided this platform for us to discuss these issues. And Pastor Kavaloh, as you all know, is Pastor Dr. Brighton Kavaloh is one that has been championing the PAL issues for so many of us in this part of the world. So I want to thank Pastor Kavaloh for all the work that he continues to do and has done. And I want to thank Sister Ayomi Soremekun for gracing us with her presence this time and to provide this information that she's no doubt going to be giving us, and is without a doubt going to be very vital for us. So thank you so much. At this point, I'll like to hand over to Sister Sonia Monroe, who is going to pray for us. And then after she prays, Pastor Kavaloh will be presenting. And after he finishes presenting, then it will be Sister Ayomi. And then we'll go into the Q&A. Thank you.
Okay, so let us bow our heads for prayer. Our Father in heaven, who rules the universe, we give you thanks for being with us here today. And as we enter into this afternoon's presentation, Lord, I pray that you will be with Pastor Kavaloh, that you will be with Sister Aomi, that you will give them clarity of thought and clarity of word, so that everything that is said we will understand, and that it will give us the information that we need when we go back into our work spaces. So Lord, be with those who will be listening as well today. And I pray, Lord, that you will continue to abide with us and keep us in your love and in your care. In Jesus' name I pray. Amen.
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 The host has disabled my sharing. Someone please. My
set, if you proceed.
okay, thank you.
Okay.
My desktop, please. Can see my desktop. Please come to. Hello.
Okay, I'm joining.
Yeah, please. Are you able to? With my desktop.
I think Elder Eric is
All right.
about to connect to your machine.
Yes, I'm there.
All right.
Okay.
Not that one, no. Yes, that one, yes. While you are connecting, please, I think I should proceed, shall I?
Yes, please.
Yeah. Well, we indeed are very delighted to be with you as our audience today. Those of us in the UK and also those who have joined us from abroad. Thank you for being with us. Our presentations will primarily focus on UK jurisdiction. But that said, we will, I believe, be no doubt that those of you from abroad will benefit as you identify with certain key areas that may be applicable to your setting and circumstances. As here in the UK, lockdown rules start to be lifted. Employers prepare their employees' return to workplaces safely. The primary purpose of our presentations, my colleague Ayomi and myself, among other areas, seek to address three key areas. as shown on the first slide before you, I believe. If I could remain on that one, please.
We can't see anything.
Wow. Yeah, someone is really playing.
Proceed with the share. Go to share, Pastor.
Yeah, we had already said this. I don't know. Okay. There we are now. Said this was off the screen. Okay. All right.
Amen. We can see.
Now we can see it. Yeah.
Someone is running scared. I'm ready to take this head on. Whoever is running scared behind the scenes. Just a short word of prayer. Dear Heavenly Father, as we proceed, we just want to thank you for setting us on our way. We bless you. We praise you in Jesus' name. Amen.
Amen. Amen.
As I've said,
Amen.
the three key areas as shown below on your first slide. First, where does UK COVID-19 legislation or law stand at the moment on vaccination? We don't want second guessing. We should know where it stands at the moment. Secondly, to what extent can your employer require mandatory vaccination? Now, taking those two first questions into account comes the third. What are your employment rights as a consequence or result of this? I just want to really take you to where I'll be mostly focused, albeit touch other areas as well. UK COVID vaccination and the law, where it stands at the moment. I would like, first of all, to invite you to reflect with me a legal related statement acknowledging both internationally and domestically, that is here in the UK as well. A statement by Roland Dawkins, an American philosopher and constitutional law expert, but one who also spent time on these shores in UK as a professor of jurisprudence at the University College in London, and also professor of the same department, jurisprudence, at Oxford University here in the UK. In his book, Dawkins' Law Empire, published 1998, page 9, I want you to follow me, something that has been acknowledged internationally and domestically. Don't lose me, I don't want to lose you either. Dawkins says, the rule of law requires that a state cohesion shall always be backed by law. The state's force must not be used or withheld, no matter how useful that would be to the ends in view, no matter how beneficial those ends, except as licensed and required by law, that is, by valid legislation or decisions of the courts having the effect of making law. Let me put it in simple words. Any government must follow the rule of law. State cohesion, mandation, use of force, even use of compulsory measures must always be backed by law. You can't use them for expediency. One, the state's force, no matter how useful, you may even think the end view of this is purposeful, is the right one, but that must not be at the point of breaking the law. And then, what is even more important, he goes on to say, having valid legislation, you could also or use the decisions of the courts that have the effect of making law common law. A classic example. No matter how useful the end in view, COVID-19 vaccine is going to bring. Some say if we take the vaccination internationally, even in this country, we will go back to normal. Everyone wants to go back to normal. That is an end in view, but must not be at the point of breaking the law. No matter the end result, albeit plausible. It is really with this in mind, I would like us to consider two pieces of legislation. In the UK, primary legislation, Public Health Control of Disease Act 1984 and the Coronavirus Act 2020. Both these two make it explicitly clear no one, not even a minister of state or medical doctor, has been invested power to administer on you medical treatment or vaccination. These two. I have referred to them in the past, and today I'm persuaded to give you the reasons, then assuming you and I know. Obviously, you will have individuals who are incapacitated, mentally sick, or minors, children. You will have third parties step in. But for you who have your mind intact, it can only be by consent. These two in the UK make it explicitly clear no one can force medical treatment. You can be offered. No one can force vaccination on you. In our current situation, exactly today, the 23rd May 2020, up to this point, as you can see, these two pieces of legislation mean if anyone out there on our platform, you have received COVID-19 vaccination, you have done so by choice. Your liberty of conscience must be respected. If you have not received your jab, you too have done so by consent, and your liberty of conscience must be respected. Now, I just want to say, but can you help us fully understand these two? They indeed look the same. How do you come to that conclusion. Okay. Before I come to it, you will have noticed the statement I made. There are three eminent scholars, academic individuals who have reached the same conclusion. Neither the Coronavirus Act 2020 nor the Public Health Act 1984 grant the executive the power to mandate vaccination. Indeed, Section 45E of the PHA, Public Health Act 1984, and Schedules of 18, 19 of Coronavirus Act rule out provisions requiring medical treatment, including vaccination. At the bottom, they write, a policy of compulsory vaccination would thus require primary legislation. Unless this is removed, you cannot be blamed for having vaccination or not. Indeed, it was Louis Hooper, a prominent to me barrister in the City Garden Court chambers, who reached the conclusion in her article. As a matter of fact, she wrote, does coronavirus need mandatory measures? Coronavirus 2020 Act. Her conclusion was this. Her conclusion, it is clear that mandatory medical treatment and vaccination are explicitly prohibited by the Act. However, things we are going to touch for you today, in spite of all this, there is, however, potential for abuse, leading to infringement of civil liberties and human rights, unless the powers contained in both legislation, but for our purpose, contained in the Coronavirus Act, are exercised lawfully. There could be times when this law, which is mandatory, can be exercised unlawfully. Power under the Act are restricted to those circumstances where the exercise of the power, mark those words, is proportionate and necessary, and for the shortest time possible. What is reasonable, proportionate, necessary is likely to change over time and is open to all manner of interpretation. No wonder she says, no wonder she says, as with any legislation dramatically affecting people's civil liberties, there is a need for vigilance to ensure the state does not overstep its boundaries. If I should go back, a classic example, she gave the idea of what is reasonable, what is proportionate, what is necessary. That's where we are and will be. This will be a battlefield for legal issues, God forbid, possibly for time to come. Why? Here is just one example. Reasonableness in Schedule 21. A classic example. Does not clarify what may or may not be reasonable grounds to suspect. In the case of O'Hara versus Chief Constable of the RUC, making, this is where something comes in, making an arrest based on suspicion is in relationship to a constable's subjective state of mind, what that person thinks is reasonable. But for there to be reasonable ground on the issue we are dealing with, it will need not a subjective test, but an objective test. Where the green is, you can see for yourself. As a result of this uncertainty sometimes, the Coronavirus Act, the act lacks clarity as to what this objective test may be, particularly as common symptoms of COVID-19, such as high temperature or persistent cough, can also be caused by entirely different illnesses than COVID-19. What is reasonable? What is proportionate? What is necessary? If I may take you to now run through why vaccination is not mandatory. Public Health Control of Disease 1984, which was brought in because of tuberculosis epidemic in 1984. Possibly some of you were around then. That's why it was brought in. From sections 45A, where I'm taking you at, to T, powers were given to a relevant minister to make regulations to prevent danger to public health and prevent the spread of infection. Those areas, the minister was given powers to protect the public health. So you'll see 45A, we begin with 45A. Any reference to infection or contamination is a reference to infection or contamination which presents or could present significant harm to human health. A minister was given powers to prevent that. Next, 45B, powers to regulate. Indeed, a government minister was given regulations, look, 45B, to do what? Health protection regulations in international travel. The appropriate minister may by regulations make provision for what? For preventing danger to public health from vessels, aircraft, trains, or other conveyances arriving at any place. The powers were given to the minister to make that regulation. B, more or less the same. C, by giving effect to any international agreement or arrangement relating to the spread of infection or contamination. The powers were given to the minister. B, next. C, B, it was international travel. Look at that. We come to B, health protection regulations, domestic, in the country now. Look, 1, the appropriate minister may, by regulations, make provision for the purpose of preventing, protecting against controlling or providing a public health response to the incidence or spread of infection or contamination in England and Wales, where from risks originating there or elsewhere. I want you to see, okay, let's come to 3. Regulations were also rolled out to these. Look at this. A, imposing duties on registered medical practitioners or other persons To do what? To record and notify cases or suspected cases of infection. It never mentions vaccination. Who next? B, conferring on local authorities or other persons functions in relating to monitoring of public health risks. But folk, I want you to pay attention to C, very vital. C, imposing or enabling the imposition of restrictions or requirements on or in relation to what? To persons, things, or premises in the event of or in response to a threat to public health. So indeed, there will be an imposition, restrictions, where individuals, premises will have to be dealt with so that the spread of infection is dealt with. No mention of vaccination or medical treatment. 4, the restrictions or requirements mentioned in 3C, just before 3C, a requirement that a child is to be kept away from school. We have gone through that. Those powers were given to the minister. Schools were closed. B, a prohibition or restrictions relating to holding of an event or gathering. Churches were closed. Schools were closed. Theaters, football grounds. The minister has been given clearly a duty there. No mention of vaccination or medical treatment. Let's come to D quickly. D takes then a step further. It's going in steps. 45D restrictions on power to make regulations under Section 45C. The Minister of State now is being told on 45C, where you have been given powers, it's not a blanket, it's not a blank check. 1, look at this. It's reminding where we just came from C. I'll come back to that very quickly. 1, regulations under Section 45C may not include provision in imposing a restriction or requirement by virtue of subsection what? 3C. Watch, let me take you. 3C in blue, 3C in blue, where you can make restrictions on people, on premises, but see what it says, 3C. Of that section, unless the appropriate minister considers when making the regulations that the restriction or even the requirement is proportionate to what is sought to be achieved by imposing it. You can't impose by imposing sex. So you have been given powers, but they'll have to be tested, objective test, proportionate. 2, regulations under Section 45C may not include provision enabling the imposition of restriction. Going back to 3C, sorry, to 3C. Look, 45C, 3C. When you impose restrictions which will affect the people, things, or premises, look what the minister is being told on 2. Of that section, unless the regulations, your regulation are put in place, provide that a decision to impose such a restriction or requirement may only be taken if the person taking it considers, when taking that decision, that the restriction or requirement is proportionate to what is sought to be achieved by imposing it. If you are imposing something that is biased, you are out of line. It must not be one-sided. Proportionate means take both sides and balance them. Then when it comes to, this was what? 4D, we now come to 4C. 4E, medical treatment. See how it reads. 45E, regulations under section 45B or 45C may not include provision requiring a person to undergo medical treatment. Medical treatment includes vaccination. Let me take you back. What is being said is this. 45B makes no mention of medical treatment or vaccination. 45C makes no mention of vaccination or medical treatment. No wonder the caution in 45D. Then in 45E says, there you are. It can only be by consent. Can only be by consent. Where is the law at the moment? It's exactly today, the 23rd of May. You, by law, no one has been given the authority to vaccinate you against your consent. Not even a minister of state or medical treatment. What you're seeing there, from 1994 PHA to coronavirus, still stands this very moment. Dawkins says this can also be enforced by common law. Common law. Yes, there it is. What the case law, the common law says regarding RT and adult refusal of medical treatment. This had to do with someone who refused when they offered blood transfusion. The person said, I would rather die than have blood transfusion. In the Court of Appeal, Civil Division, Lord Donaldson, on this case, reported in the All England Law Report, says, quote unquote, and this is now a case law being followed in the hospitals. An adult who suffers from no mental incapacity has an absolute right to choose whether to consent to medical treatment. Can I add, has an absolute right to choose whether to consent to vaccination or not. Absolute right. This right of choice is not limited to decisions which others might regard as sensible. There'll be people arguing, this is not sensible. That is not sensible to you, to me, but is sensible to them. Liberty of conscience. But don't you know that if we all did this, the end in view will be taking us back to where we were years ago, a year ago. We'll be back to normal. But not at the expense of the rule of law. In the legal frame, British Journal of Medical Practitioners, 2009 says, you can exercise your right to be subjected to what would be an assault and, you can exercise your right not to be subjected to what would be an assault and battery under English law. Medical treatment without consent could be an assault and battery. Can I be bold to say Vaccination treatment without consent will have the same charge because they are both twin, unless the two are revisited and changed outright. Landmark chambers, public health and public law, where the red is, my time is up, where the red is. Thus, a person can be isolated, yes, and offered appropriate treatment, yes. Short distancing and the rest. And kept in isolation until the risk of infection is reduced, yes, but cannot be required to accept any medication, any vaccination which is offered. That will be unlawful. That's where we are. You may say, but, oh, we are hearing no job, no job. Yes. Why? Because the legislation is now changing. In spite of giving you that background, the landscape is changing. Those in the caring settings are the ones now in the front line. I filled my consultation Friday, coming up to midday. You remember that? Opening consult, making vaccination a condition. What that means, mandatory in all adult care homes. If mandatory was already there for vaccination, this could not have come in, could not have quite triggered when the law is already there. Currently, this to me is a testing ground for things to come. No wonder I kept on telling people, let us respond to this. Let us respond to it. Look, summary. We are seeking your views on a proposal to make COVID-19 vaccination condition of deployment, meaning mandatory in order adult. Obviously, who would not feel sympathy for our elderly folk? But my question, will it stop there? Will it? Oh, all I can say, Isaiah 41, verse 10. And I'm finding people who have been gripped with fear with this COVID virus. No one was really, I don't recall flu getting this kind of grip around the world, even in here, in our country. In fact, what is very bizarre, those who have been vaccinated are in great fear. Those who have not been vaccinated, there's a grip of fear of unknown. Isaiah 41, 10, 13. Whether you have been vaccinated or you have not been vaccinated, you have made that decision by choice. Therefore, I'm encouraging you, fear not. God says, I'm with you. The choice you have made. Be not dismayed. I remain your God. I will strengthen you. I will help you. I will uphold you for the decision you have made with my right hand of righteousness. People will make the choice to have vaccination, not to have vaccination, for that which they themselves know, and God. And no wonder, in verse 13, for I, the Lord your God, will hold your right hand and say, fear not, I'm going to help you. Ellen G. White, in her book, Education, 178, the complicated play of human events is under his divine control amidst the strife and tumult of nations. He that sits above the cherubim is still in control. Therefore, I include myself and everyone within at least listening to this. For the decision you have made, in fact, if I may say, if you feel you took the job by fear because you were pushed, possibly there is a case to answer. Should not have been. You should not have been pushed. If you have not been vaccinated because someone has pushed you not to be, that person has a case to answer. It must be by consent. When you have weighed all the issues, because this thing is moving. It's not static, it's dynamic. My colleague will be taking you further. In fact, I'm having to curtail what I had here. It's dynamic because it's not a foregone conclusion that by next week we'll be in the same legal landscape. But for now, when I say now, I mean even those in their care homes. If you have left your job, it must be on another reason. But if it was on a mandatory vaccination, there is a case to answer. Because up to this point, the law has not changed. But for you and me, let us trust God. He is still in control, guiding the affairs of your choice. Thank you.
Thank you very much, Pastor. Excellent presentation and vital information there. And at this point, it's my pleasure to invite Sister Ayomi Soremakun. Sister Ayomi, this is your time. You're very welcome.
Is everybody able to see the slides? Okay.
Yes.
Right. Yes, we can see it.
Yes,
and hear me. Okay.
Yes, we can.
Lovely. All right. So just to carry on there from Pastor's excellent presentation there on where we are and giving you a good understanding of the law and spiritually as well where we are. I'm going to sort of maybe focus a little bit more now on the practical side of this presentation as we promised. And we'll just begin with an introduction of the presentation. And we'll sort of talk about some of the parameters of the presentation. We'll then have an overview of your employer's obligations and considerations regarding the UK COVID-19 vaccine, and followed by an overview of your employment rights. I just think that that's important because sometimes in these sorts of situations, we can become, sort of very fearful and afraid of what our employer's doing and why they're doing it and why they're saying it. But sometimes to understand where they're coming from and what maybe could be driving them could be helpful in indeed sort of, helping us to understand the fuller picture and understand our rights within that wider context. We'll then look at some of the key questions that Pastor Kavaloh and myself have heard from various people. And that's just that maybe some of the questions that you all might want to ask today, can be answered in full in the presentation because we may not have so much time in the Q&A. So we just wanted to create this as a bit of a resource that you could go back to it as well later on if you want to and really understand some of the answers to the questions, the common questions at least that many of you are facing. I'll add here that there is an assumption taken that the majority of the audience are from a faith-based background. So this is more tailored towards this, if not Seventh-day Adventist, at least some type of faith. And then we'll then go on to look at 2 UK employment tribunal case examples to see what we can learn from previous cases that have been tested at tribunal. And then after that, I'll just signpost you to some further resources that you can reference to be able to provide you with further support and assistance if you need it. As we've said, we probably won't be able to sort of go through everybody's specific situation and case today. Okay, so to get straight into it, the focus of this presentation will very specifically and exclusively focus on our title piece, that is the UK COVID vaccine and your associated employment rights at work. And that's just due to time limitations. We won't be able to sort of discuss everything sort of, in terms of employment law in general and employment law in general, as well as coronavirus in general and how it affects every aspect of your employment situation. We're going to have to be very targeted and specific on this, as there's lots of information, as you'll see. But as we say, this is more of a resource. Don't be overwhelmed by the information. It's just there for you to refer back to if you need. Also, I'll focus on the main employment laws discussed here. Those laws are generally stable across England, Scotland and Wales. There are a few slight changes and nuances that apply to Northern Ireland, but generally the laws will be stable across the UK. Please do note that the UK COVID-19 vaccination programme is also, as Pastor has said, it's evolving, it's complex, it's largely untested from an equalities, ethics and human rights standpoint, as well as a health and safety, civil and employment law perspective. Therefore, there are currently many unknowns and very likely a few subject to changes coming as well. And I've explained that why we'll be focusing on the on the employers as well as the employment situation. But I just wanted to sort of also maybe just draw your minds to the fact that ultimately it's primarily the responsibility of the government, public health and the National Health Service to successfully drive the COVID-19 and C19 vaccination programme. But it's just worth understanding that employers have also been handed a very important role in this, in encouraging the uptake of the vaccine. Therefore, for many employers, no harm is intended. They simply have a task to fulfill to protect employee health and safety and help drive a return to normal life as they see it. So that's just something to bear in mind as well, as I say, to sort of maybe remove some of the fear from what maybe your employer may be doing and just maybe try to understand where they're coming from and then understand your place within that context. And finally, please note that this presentation is not intended to influence anyone's decision on whether to refuse or accept the COVID-19 vaccination. That is, of course, an individual decision. Okay, so to begin, I'm just going to outline some of your employers' rights. We'll go straight into it and key considerations regarding the UK COVID-19 vaccine. So firstly, as Pastor has mentioned there, we must note that generally in the UK, vaccination has not been made mandatory. The government have not legislated for this so far, and therefore no statutory provisions exist requiring individuals to be vaccinated. So to date, vaccinations as a form of medical treatment still require recipients' voluntary and informed consent. That has not changed. However, it may sound a bit contradictory, but please note that despite all this, your employer can, in theory, request that you have the vaccine and make it a condition of your employment. And this is because, as we say, things are changing very quickly, and we'll explain why that is the case as we go through the presentation. However, they currently still cannot force you to have it if you reasonably, and as Pastor said, these are the key points, and we allude to this a lot, if you reasonably choose to decline. Okay. Just indeed to sort of highlight here, this point that we've raised here about sort of employers being able to request that you have the vaccine but not forcing you is a very important one, because many people think that it's actually that employers cannot request that you have the vaccine. But actually, this is a very untested area in UK law. That means employment tribunal. The way that as Pastor has spoken about, and we're going to sort of discuss quite a bit here, the key thing for an employer in making any requirements is to make sure that their requirement is fair and reasonable, that it is a fair and reasonable instruction or management request, given a legitimate aim, and that is a real business need. In this case, they're talking about obviously reducing the risk of getting COVID-19 at work. They would also need to prove, after conducting a risk assessment, that the management request that they've given you was a proportionate measure for them to take to achieve this legitimate aim, which we said is a real business need. It's quite important in this presentation because this is the foundation upon which employers are standing to be able to request that you take the COVID-19 vaccine. So what are some of your employers' rights considerations and legitimate aims around the vaccine issue? Well, this is in no order, but some of the main ones include the fact that they are required to do everything reasonably practicable to minimize or avoid risk. This will involve collaborating with your organization's health and safety, occupational health, HR, and medical professionals to assess risks, as well as consulting with yourselves, that's the employees, or your trade unions where appropriate, to assess risks of potential hazards and harm to staff. This is particularly important if you're working in an atmosphere where there may be clinically extremely vulnerable people present, and also this is also to affect, of course, visitors that may come to their site as well. They'll then need to implement suitable measures to avoid all of these risks or hazards from occurring. And so that's likely to involve, again, sort of, risk assessments following government guidelines to make the workplace COVID secure. So that's, things like clearly signposting, hand washing, sanitizing amenities, encouraging social distancing, use of adequate ventilation and PPE, mask wearing, regular testing, working from home. All of these are measures and suitable alternatives that your employer can enforce to be able to indeed ensure that they are COVID secure. They're sticking to health and safety guidelines to make sure that the workplace is indeed a safe place. Following health and safety recommendations from bodies like the Health and Safety Executive and the Institution of Occupational Safety and Health, and developing a vaccine policy will also be things which your employer will need to do to make work expectations, work aims and objectives clear. And this will include outlining how discrimination will be tackled in line with the Equality Act 2010, as well as how your personal data will be protected if they collect it, and the reasons why they're collecting it, how long they're going to hold on to it for, these sorts of issues. And that's in accordance with the Data Protection Act. And also in line generally with the Health and Safety Act 1974. Legal obligations also extend to, and indeed some of the laws that will be governing them are the Health and Safety Act at Work, Act 1974. And this obliges all employers to take all available reasonable and practical measures to reduce and control workplace risks, provide safe systems of work, and ensure staff members' health and safety. Now, this is really important because under the Employment Rights Act of 1996, employees have been awarded a critical right, and that is the right not to be subjected to any detriment by any act or any deliberate failure to act by his employer, and in circumstances of danger which the employee reasonably believes to be serious and imminent, and which he cannot reasonably have been expected to avert, the employee can refuse to return to his place of work or any dangerous part of his place of work. So this is the right that you as an employee have to indeed not to be subjected to any detriment, either on the deliberate or the neglectful part of your employer, right? So they have this in mind. They have to think about this when they're making decisions around how they're going to make the workplace COVID secure. Now, these laws could serve, of course, as we can see, to incentivize some employers to encourage and to even request employee vaccination, in addition to other protective safety measures that they may undertake in order just to be seen to be actively providing a safe and a danger-free workplace. And then, of course, most critical to employers is the fact that failure to do so, and this is really key, this is where your employers are probably really, this is where they're really concerned, this is where the focus is. Because failure for them to do take these measures would constitute a breach of their duty of care, which is a physical and psychological duty that they owe to all their employees. And this will be under health and safety laws. It would also imply a breach of the implied duty of mutual trust and confidence that an employer and an employee have between them that make up the employment relationship. This can open an employer up to an unfair dismissal claim from an employee. And this is where an employee makes the claim that they were dismissed for an unfair reason, or that they suffered under the dismissal process. Like, for example, they didn't get the adequate amount of warnings that they should have received before they were let go from the organization, especially if your employer instantly dismisses you. So they have to prove that they followed a fair process, and they have to prove that they also dismissed you, if that's what they choose to do, for a fair reason. Employers are also going to be open to claims of constructive unfair dismissal. This is where, for example, an employee decides that they can't work anymore with this particular employer if they're mandating, let's say, or requesting that everybody be vaccinated. So that employee decides to resign and say that I have to resign because I can't work. My employer's conduct has indeed been so detrimental to me that I can't be expected to continue working there, and I've been forced to resign. That's what constructive unfair dismissal is. And all of this employers are thinking of, and they also are very conscious as well of disability discrimination claims that indeed employers can make as well. So it could be that could be around the anxiety and stress caused by indeed working in a place where they were concerned as to whether they were going to get sick, whether they were going to get COVID. Maybe they have people at home who are shielding, who are clinically extremely vulnerable. And so that could really awaken some anxiety and stress. And also organizations and employers would be liable under health and safety laws as well. If indeed somebody says, somebody has extreme issues already with anxiety and stress, and that's kind of classed as a disability, they would indeed now be falling foul of disability discrimination laws. They'd also be potentially facing personal injury claims. So if an employee contracts a virus at work, resulting from the inadequate health and safety protections that the employer has provided, this also would be an issue for the organization, if of course a link between the two can be successfully proven. And that's not actually very easy to do, because indeed to be able to really prove that you got coronavirus from work and not from somewhere else, and not maybe from somebody, maybe your partner who worked in another place and gave it to you, it's very difficult to prove that. But potentially these are the sorts of risks and issues that an organization are going to indeed be concerned about. And just to sort of add in from there, we can see that from this McKinsey report that came out earlier this year, where it was noted that employees' hopes and fears for the future as concerns returning to work. If you look at number 2, the one which is highlighted there in pink, we could see that out of all the fears that employees have cited regarding returning to work, they had 4 top fears that McKinsey noted, and number 2 was an increased chance of getting sick. So we could see that organizations have a legitimate aim and concern about, and indeed potentially employees feeling anxious about this, and indeed also making sure that they are fulfilling their requirements under health and safety laws to ensure that as many as possible of their staff members don't get sick. Additionally, your organization needs to consider the fact that COVID-19 is also a reportable disease under RIDDLE, which places duties on them and all worksite controllers to report serious work-related incidents, diseases and accidents in line with health and safety and social security laws. Therefore, from an employer's perspective, encouraging the uptake of the vaccine is, in their mind, really just helping to reduce the spread of the disease and potentially the number of workplace incidents that they would then have to report, as well as generally protecting the work environment and showing compliance to all relevant regulations and legislation. That may just be their intent. I know there are some, unpleasant employers out there, but some of them, that just really is all that they are really concerned about. It's just about, the legislation and what they need to be following as an employer to be compliant. Finally, also, but by no means least, as this is a big one, your employer needs to ensure that they avoid discriminating against employees who may be vaccine hesitant. And that means that they're reluctant or refusing to vaccinate despite the availability of vaccines. And this would be based on what we call protected characteristics. That's just essentially distinguishing features that different employees may have that are protected by law, as Pastor has mentioned. All of this is outlined in the Equality Act 2010, and that includes age, disability, gender reassignment, everything from race and religion onwards. Okay, so now hopefully you understand a bit better the concerns your employer likely has on their mind where they may be potentially coming from, if they even sort of go as far as trying to sort of request that you need to be able to indeed have a vaccine. And this is, as we say, potentially concerning, just concern for everybody's welfare, and indeed just making sure that they are compliant. So we're now sort of turning a little bit more now to what are your key rights, and what should you know and or consider as regards the vaccine situation at your workplace. Okay, so this is especially geared towards those, like I say, who are facing mandatory vaccination potentially at work, and indeed, and if you feel uncomfortable with this. Those people who are happy to be vaccinated, of course, and are vaccinated, of course, that's very straightforward. You just sort of continue and to sort of follow the government and your organization's guidelines. Okay, so what do you need to know? Well, firstly, you must know that enforced vaccination would constitute a criminal offence against a person and an unlawful injury, which could lead to claims such as assault and battery under UK civil criminal law, and form the basis of a civil lawsuit. As pastors discussed, I won't go into the Public Health Control of Disease Act again, but again, this, very basically, it's just sort of saying that nobody needs to be compelled to receive any form of mandatory medical treatment, which includes vaccinations. Other laws that govern and are relevant here for employees include Article 8 of the the European Convention on Human Rights, and that is the right to respect for private and family life, home and correspondence. And that protects people from forced medical treatment and procedures, as well as physical and psychological interference, which also again includes mandatory vaccination. Now, Article 9 also looks at this, but it looks a little bit more, I suppose, relevant to us in that it's looking at freedom of thought, conscience, and religion. And that protects religious freedom and the right to hold a belief, manifest it, and not act contrary to it. And this is supported as well by sort of Article 10 and Article 14 of the same human rights legislation, which also supports the freedom of thought, conscience, and religion, and also the ability for you to change your mind. So you could sort of, be working in an organization and you maybe came in an atheist, and maybe halfway through the time that you're working in that organization, you decide to turn to Buddhism or Hinduism or Christianity. You have the right to change your mind. And also to hold whatever you want as a belief without fear of discrimination. Of course, as we said, for you as an employee, the Equality Act, again, as we've mentioned, is very important. It protects you from discrimination. Okay, so now we have an understanding of the main key rights of both your employee and you as an both your employer, and you as an employee in light of the UK COVID-19 situation. I'm now going to turn to look at how all of this syncs together, in addition with some other routine duties, responsibilities, etc., by law that govern both the employer and employee relationship. Just to be able to indeed sort of maybe give you now some answers to some of the questions that we've been commonly hearing from you all in light of some of the scenarios that you're facing right now or may indeed face in the future. So the first question, and probably the most popular question, is indeed, can my employer require me to have the COVID-19 vaccine? So the answer to this is very tricky, as we've said. Technically for the laws and so on that we've explained, technically they can't. But actually, your employer may request that you take the COVID-19 vaccine as a reasonable management instruction. And if they can provide a fair and reasonable justification for doing this, and that could be, for example, compliance with health and safety laws, or because to protect vulnerable patients, or because maybe part of the job involves going, traveling overseas, then they would actually be in a position to be able to potentially defend this management instruction for you to take the COVID-19 vaccine. So it's not a clear-cut case. And in fact, Barchester Healthcare, Pimlico Plumbers and Care UK have already progressed with doing this, as maybe some of you, if you work for these organisations, will already be able to attest. Organisations can argue that they have a proportionate legitimate aim, remember that means a real business need, for taking this action and developing a vaccine policy, such as fulfilling their duty of care to protect employees, visitors, and the vulnerable in their workplaces, and potentially also to avoid claims from other staff under health and safety laws who may report feeling unsafe to come to work in an environment where others are unvaccinated. Your employer cannot force you to take the vaccine, however, particularly if you have a fair and reasonable justification for not doing so. So, for example, a legally exempt underlying medical condition, like an immune suppressed person potentially, or someone with a mental health condition like a severe form of anxiety, as we've discussed, or an allergy, or a protected characteristic under the Equality Act 2010. Furthermore, employers are still being advised not to mandate employee vaccinations to all staff just yet, because not all age groups are currently even eligible to have the vaccine. I think the current age group, I think as I've seen it on the NHS website, is you have to be 34 and above to be able to be eligible to take the vaccine. So mandating the vaccine for people who can't legally acquire it would actually constitute age discrimination. So as we say, everything is evolving. It's all kind of changing. Things are coming into place slowly, but indeed, these are just the things for you to think about that potentially your organization can, if they feel they have a legitimate aim and they're able to reasonably and fairly be able to indeed defend the reason why they've requested this. Okay, so the next question is indeed, can my current contract oblige me to have the COVID-19 vaccine? Now, this is an interesting one because employers can choose to make taking the vaccine a condition of your employment. But this is oftentimes now in the contracts only of newly starting employees. They can even ask existing employees to agree to what we'd call a variation, which is a change to their contract terms. And this will be a change to include a medical examinations clause. They will do this only if this clause already doesn't exist in your contract, because doing this means that they'd have to go through a collective consultation process, or at least a consultation process with the people they want to mandate this for. And so this, it takes time. It's, sometimes, it doesn't it's not a straightforward process to be able to indeed do, and employees sometimes don't agree to it. They can consult you, but you don't have to agree to it. So they prefer not to sort of really to take this approach if possible. But having said that, many people think, oh, it's not in my contract. I'm pretty sure about that. When I read my contract, I didn't see it there. But actually, it may be in your contract, but you're just maybe not aware that it is there. And that's because sometimes these clauses aren't straightforward. They don't sort of come as an express term, but they come as a flexible term. And so this means that, they have a clause in your contract that allows for an employer to make a change to your contract if they think that they want to do this for whatever reason. So it's given them the right to be able to indeed change your contract. You've signed that already without realizing it. You didn't think it was going to be related to vaccines necessarily, but they've put in there a clause that says that they have the right to be able to vary your contract if something arises and they feel the need to do that. And this is sometimes how they try to get around having to indeed, indeed just straightforwardly do a consultation. They could sort of say, well, they could rely on the fact that, they have a clause in there which says that they're allowed to change your contract. Either way, however, employers are still expected to consult with existing employees before significantly changing any contract terms in order to secure your agreement and your voluntary consent. And this is especially true still for medical interventions. This still holds regardless, even if they have that flexible term in your contract, but it just does give employers that little bit more kind of enforcement to be able to indeed maybe try to indeed make a change to your contract if it's there. However, it's worth also noting here that that indeed less scrupulous employers can try to enforce a change to your contract without your consent. So now they're supposed to ask you for your consent to be able to indeed change your contract, but they can force this, and this is known as unilaterally imposing a change. They may also, another approach they may take is to terminate your contract if you refuse to change it, and then offer to reinstate you on a new contract, subject to your acceptance of the new contract's terms. Of course, that new contract would have some sort of medical examinations clause. So these are some of the unscrupulous methods that some employers may take, and you need to be aware of this because this does happen. And these are high-risk strategies, but they do occur. And in the NHS, this happened in 2016, where they tried to enforce a change, unilaterally impose a change on the contracts of their existing junior doctors in 2016. But they were unsuccessful because all of the junior doctors stood firm and didn't allow them to change the contract. And so they were only allowed to make put that clause now into the contracts of new junior doctors. What can you do if this happens to you, if your employer decides to unilaterally impose a change and enforce a change to your contract? You could do one of three things. You could work under protest. So that's where you temporarily continue to work while at the same time pursuing legal action for breach of contract against your employer, for them trying to change your contract. That's a breach without going through the process of consultation and securing your agreement. That is a breach of contract. But to be able to for this to be able to be successful, you also need to maintain that you frequently make clear to your employer that you do not accept the new contract changes. If you don't make this clear, it could be taken and seen that you accepted it because you kept coming to work. You went along with it. You didn't really make a fuss. So they could indeed, it could be seen by an employment tribunal that you've accepted those changes, and that indeed the employer was reasonable to think that indeed you'd accepted it because you carried on working. You could also resign and claim constructive unfair dismissal. And this, you would have to have 2 years service at your workplace to indeed be able to claim constructive unfair dismissal. Or this doesn't apply to contractors. This only applies to employees. Contractors aren't protected by that right of being able to claim constructive unfair dismissal. But indeed, there are other rights which indeed you would have as a contractor. We'll come to those. But indeed, you'll be able to claim constructive unfair dismissal, as we discussed before. That just means where you feel forced to resign because your employer's conduct or what they're mandating that you do, you cannot go along with it. You cannot work under those conditions. So you're forced to resign. And then, of course, you can pursue your constructive unfair dismissal. You can pursue a claim for that. You could also indeed simply refuse to work under the new contract terms given and just leave it and just leave. You could do that as well. For dismissal followed by re-engagement on new terms, as we say, when they terminate your contract and then offer to reinstate you on a new contract where they change the terms and indeed added in that medical clause. You can also claim breach of contract or unfair dismissal. Again, you'd need 2 years service at your workplace to do this first. And if they do not agree to the, if the organisation don't agree to the changes, this would constitute an unfair reason for a dismissal and would also show that an unfair process has been taken. This is why you'd also be sort of looking at unfair dismissal, because unfair dismissal is different to constructive unfair dismissal, in that constructive unfair dismissal, as we said, is where you want to resign because indeed you cannot continue to work under the conditions that your employer has set for you. Whereas unfair dismissal is actually where they dismiss you. So in this case, they've terminated your contract and offered to reinstate you, but still they've dismissed you. So you're able to say that that dismissal was unfair. They didn't go through the proper consultation process. They didn't give you the normal stages of a dismissal process, which includes the 3 stages of warnings. All of these things you could indeed sort of cite as part of your unfair dismissal claim. Okay, can my employer lawfully dismiss me if I don't have the COVID-19 vaccine? So potentially under dismissal justification, some other substantial reason covered by the Employment Rights Act 1996, they can potentially be able to indeed dismiss you. This would again be based on whether your employer could argue that they have a potentially fair, substantial and reasonable reason for mandating the vaccine at your place of work. If so, they could discipline and subsequently dismiss you for not following a reasonable management instruction, which all employees have a duty, an implied duty by law to follow. So failure to comply with without a reasonable explanation for your refusal as well, because it's not only reasonableness on the employer side that employment tribunal will be looking at if it ever got to that stage. They'll also be looking at how reasonable you were throughout all the processes and all of your requests. So indeed, if you failed to comply and you didn't have a reasonable explanation for your refusal, you're more likely to be successfully challenged by this if you wanted to indeed take this up with your employer, especially if your refusal had serious consequences for your employer. This is still not quite so straightforward for employers. They still have to show fair and reasonableness throughout the process by proving that they first consulted with you or your trade union to invite and consider your reasons for refusal, as mandating a vaccine is arguably a change to your contractual terms and conditions, as we've discussed. They also need to show that they carried out a fair disciplinary process, one which will follow the ACAS code of practice or the Labour Relations Agency in Northern Ireland, as employment tribunals are obligated to consider this in relation to any disciplinary or grievance cases. They also need to show that they considered suitable alternative arrangements first. So, for example, the use of PPE, frequent testing, hand washing, etc., etc. Maybe letting you work from home instead, or redeploying you somewhere else in the business. They would need to be able to successfully prove that they did all of these things before they could sort of have a successful claim. They have to show they accommodated your request while still minimizing their risks and keeping the work environment safe. So they have a burden of proof on their side to be able to indeed actually show that their dismissal can actually be upheld in a court of in an employment tribunal. Okay. So people have also asked, can my employer request that I tell them if I've been vaccinated? Well, your employer can ask if you were vaccinated, if you were vaccinated initially as part of a reasonable management instruction by them. And wherein this is so, they can defend requiring this information as a legitimate reason, as we said, a legitimate aim. A legitimate reason under, GDPR legislation. They could sort of say that they needed to do this to be able to indeed to keep their records, to verify that you've actually done this and for compliance purposes. So they would indeed, they can actually ask you, if they were the ones who asked you to get the vaccine, they can indeed then legitimately say, well, we need for our records to know, have you gone through with it? And so they know who's actually been vaccinated in the organization. And your employer must process this information securely after conducting a data protection impact assessment, and only for the purposes and timescales that they will need to specify to you first, but they'll have to be able to sort of and be able to follow that process very much in line with what they've told you, because this is covered by the Data Protection Act 2018, which indeed considers employee health data to be special category data. And so it has to be dealt with very securely, and indeed really only asking you what they need to know, asking you the bare minimum, because indeed, if anything happens to this data or this information, this is considered extremely serious under data protection law. If your employer did not ask you to be vaccinated, however, they would need to provide you with a fair, reasonable, and lawful purpose for requiring you to volunteer this sensitive special category data information. And you can refuse to do this, but indeed, that's at your discretion to be able to do. The critical question, I think, the final question I think we're going to just cover here at least, and then it's open to all of you to ask the questions that you have, is can my employer lawfully dismiss me if I refuse the vaccine on religious grounds? Well, as religion is a protected characteristic, as we discussed under the Equality Act 2010, it would not be lawful for an employer to discriminate against an employee on this basis. Employers will need to consider their approach to this when developing their vaccine policy and undertaking their risk assessments. Now, this may include treating employees with a religious objection similarly to an employee with a legal medical exemption. This will involve considering suitable alternative measures, again, as we've spoken about, to accommodate the employee. And all of these measures would have to show fairness, reasonableness, and proportionality. In order to defend a decision to dismiss you, even on religious grounds, an employer will need to show that they had a legitimate aim, a real business need, and the approach they took was a proportionate measure of indeed achieving that aim. So as regards discrimination claims specifically, they'll need to prove that there were no less discriminatory means available to them to employ to mitigate their risks, and they would also need to balance the proportionality of their decision against all of those human rights and discrimination and employment laws that we discussed. They would also need to ask themselves and be able to answer questions like, how much is there, was the risk within the organization reduced by using vaccination, specifically in light of alternatives that were available to them? They would need to answer questions like, do vaccines reduce transmission, or do they just suppress symptoms? Like, what really is the impact of them indeed having to use this and causing somebody to have to indeed either be dismissed or undergo disciplinary action? Dismissals related to religious or philosophical belief could potentially result in discrimination claims, as well as constructive unfair dismissal claims. As we said before, that's because you could say, well, I reasonably cannot be expected to work in this with my employer anymore if they're saying that I have to have this, I have to resign, I'm forced to resign. But indeed, you could pursue a claim for constructive unfair dismissal. This usually is pursued alongside breach of trust and confidence. You could say that I have no more trust and confidence in my employer. They've done something which I don't think is correct, and indeed this is why I'm being forced to have to resign. And indeed, it's a forced dismissal. I feel that there's no other option open to me, so I have to almost dismiss myself. But there are two things to note here if this case ever went to tribunal. Meaning you need to be clear on your rationale for objecting. So for other religious organizations or philosophical belief holders, they've argued against having the vaccine because they believe in only using natural remedies, for example, as part of their belief system. Maybe Rastafarians, etc., may indeed say this is a reason why they won't be taking the vaccine. Or some object to the fact that the vaccine's development involved use of fetal cell lines. For some religions, that's a critical issue for them. Or that the vaccines were tested on animals in their development. So all of these are sorts of, the objections you need to think about. What exactly are you objecting to? What is your rationale? And be careful with this one as well, because many things are tested on animals that you might otherwise be using. So if you want to indeed say, well, I don't want to take the vaccine because it's been tested on animals, be very clear on your reasons for this, because otherwise this will come out in an employment tribunal and affect your ability to be successful. Under the religious and philosophical belief category, something else to note is that the belief does not need to be shared by everyone in your particular religion. So employers will be required to review every case on an individual basis and come to a fair and reasonable conclusion based on the information and rationale that you provide. So you don't have to say, well, I don't know if my church or my religion or whatever will back me if I say this. If they do an investigation, the church may say that, or my religion may say this, and so I may not be supported in my convictions. You don't have to be backed by your church. As long as you have a good rationale, why you were doing it, this is the rationale you need to provide and be able to back that up with evidence, not for your employer, because if they ask you for this, that could again be discrimination because they're treating you differently to how they treat other employees. But if you went to employment tribunal, you would need to be able to indeed explain your rationale behind your reason. Okay, so just to be able to also understand what you need to know if you're going to indeed claim religious and philosophical belief discrimination, under the Equality Act 2010, certain criteria must be satisfied, and that is criteria set out by the Equality and Human Rights Commission Code of Practice on Employment 2011, and has been solidified in the Employment Tribunal case of Granger versus Nicholson, and that now really affects every case of religious discrimination belief. You have to be found to be satisfying these criteria. The belief must be genuinely held. It must be a belief and not just an opinion or viewpoint based on the present state of information available. So you can't say, well, I just read this thing, in the newspaper, maybe today from The Guardian, and it said X, Y, Z, and that's why I believe that, and this is why I'm doing it. It can't just be something that is an opinion or a viewpoint that you've just picked up today just because of the way things are right now. It has to be something that is genuinely held, a real belief that it's deep-seated, a real value that you have, and that you can demonstrate the effect that it's had in your life. It's genuinely held. It also must be a belief as to a weighty and substantial aspect of human life and behaviour, which in this case it is. It's relating to the COVID-19 situation. It must also attain a certain level of cogency, weightiness, seriousness, cohesion, and importance. And so indeed, it's really got to make sense. And it must be worthy of respect in a democratic society, not incompatible with human dignity, and not conflict with the fundamental rights of others. And you know, this is a bit of a catch-all term, but generally, as long as it's not hurting somebody or causing somebody to be at a serious detriment by maybe if you've sort of decided it's my belief that I'm going to go and, blow up everybody in a particular in a particular area, that would be considered worthy of respect in a democratic society. And to help demonstrate this, practically, I thought it might be helpful to get a picture of how other cases involving religious discrimination have actually played out in employment tribunals in the past. So in the first case of Pharrell versus South Yorkshire Police Authority, the claimant here was employed as a principal intelligence analyst, where he was tasked to produce an annual strategic threat assessment, which included looking at terrorism. In his report, he claimed that the threat level of internal terrorism within the police force was 100%, whereas the external threat was only 1%. He also described his team's objectives to protect vulnerable people and tackle crime as irrelevant. These views were found to be driven by a range of beliefs that he held, such as that the media is controlled by a global elite seeking a new world order, and that both 9/11, the Twin Towers calamity, and 7/7 bombings were false flag operations that had been authorized by the US and UK governments in order to gain support for foreign wars. He then described the police as being clearly complicit in the evil due to their failure to arrest Tony Blair. He was then dismissed for holding incompatible views for his role, and he sued the South Yorkshire Police Authority for unfair dismissal for discrimination on the grounds of his belief. And so in this case, it may be laughable to some, it may be beliefs held by some, but the employment tribunal ruled that while the claimant's beliefs were genuinely held, and they were not just an opinion in his mind, and they did in his mind pertain to things which were weighty and that were indeed pertaining to life, but they did not, in the employment tribunal's eyes, reach the minimum standard of cogency or coherence required when tested objectively for protection under discrimination law. And they provided him with some information showing evidence against his beliefs, and indeed he still refused to change his beliefs. And so the final decision was that this was just absurd, and he indeed lost his case. Oh, sorry. The second one was a case of Kazamitjana versus the League Against Cruel Sports. And in this one, Mr. Kazamitjana Costa, which was a case which actually completed very recently in 2020, the case was heard to determine whether ethical veganism can amount to a philosophical belief, and thus a protected characteristic under the Equality Act 2010. It was noted that the outcome was an unusual one, as previous attempts to protect vegetarianism and veganism under law have been quickly defeated in the courts. This has happened several times. It's just not taken seriously at all. However, Mr. Costa's claims satisfied all the aforementioned criteria that we said that the a religious discrimination claim must indeed possess. It satisfied all of that criteria for a philosophical belief to be protected under the Equality Act 2010. And I'd really advise you to Google search this case and read it for yourself. Employment tribunal cases are open to the public on the gov.uk website and other places. But reading it really sort of made me seriously question, sincerely my own claims to faith and belief in comparison to this man. And just to give you a bit of an idea, Mr. Costa works as a zoologist, and he's very dedicated to helping animals in need, which is what motivated his decision to become fully vegan. And I'll just read you a few quotes from his case notes that you can find online. And it says, the claimant, that's Mr. Kazimierz, has a 100% vegan diet. And that extends to including even food additives. They have to be vegan too, otherwise he's not eating the food. If he's unsure of the content of food products, he avoids them and would rather go hungry. The claimant got rid of all his clothes that contain animal products. His shoes are vegan and his jackets contain no animal products. The claimant goes as far when the ingredients on food labels are not clear to contact the food manufacturers to check whether their food is genuinely vegan. He does not allow non-vegan food to be brought into his home by another person. He tries to avoid sitting on leather seats wherever possible. If the claimant's destination is within an hour walking distance, he would normally walk there in order to avoid accidental crashes with insects or birds when taking a bus or public transport. And the list just goes on. Because of him and because of the way that he genuinely lived, this is not just something he just started doing or said, oh, I would like to do, or just knew that his religion asked for and thought one day I'll do it. This is how he has been living. And they had evidence they had copious notes, the employment tribunal, proving all of these, his calls, receipts, different things. And indeed, he had been able to provide them. And as a result of his stance, vegetarianism and veganism, which has never been able to get past rigorous testing in an employment tribunal, is now a protected philosophical belief enshrined in discrimination law. Now, just to say that ETs, employment tribunals, are not going to require this level of commitment from you. This is just to sort of, just give you an idea as to the two cases, just to show you that, if you have a belief that it's just based on opinions, things that you've heard people say, things that you really can't prove, just random bits of information. Maybe you had a YouTube video where somebody said something, or a pastor preached the other week about something. This is not going to be enough. You need to be able to have something that is really substantiated by evidence. It could just be that, in your religious texts that you refer to, this is what they say. And the employment tribunal is not looking for perfection from you. They're not looking to see, well, maybe, if your religion espouses veganism, as it did with Mr. Kazimierz, that they're not looking to see that indeed, you are maybe 100% vegan in everything like he is. They may just look to see, are you working towards that? And can that genuinely be seen through examples that you can demonstrate at tribunal, even if you're not there yet, but you're just working towards it. And it can reasonably see that this is true. That's what they'll be looking for. But either way, you need to be able to evidence your commitment to your beliefs in some way. Well, I hope that's the end of my presentation. I hope that helped and answered at least some of your main questions and helped you just to understand your key rights, as well as the rights and the concerns of your employer that may be sort of, driving them to sort of maybe request maybe, a vaccination for you currently at this time. Much of it stems from a sincere belief that this vaccine will actually help to drive down infection rates and protect people from COVID and help us all to be able to return to normal. And they've also got many other laws, as we've discussed as well, that kind of, is kind of, one they need to comply with, which is also sometimes driving their behavior. So we may not agree with them, but just to maybe help you understand, where they're coming from and also where you are within this. I'm hoping that this would at least kind of give you that kind of understanding today. And again, sort of answer some of the questions that you have, and you can always refer back to some of the answers to be able to help you if you're trying to put together, understand what your legal position might be right now if you're facing a very difficult situation at work. I'll say again, however, that the situation is all very new, and therefore the relevant laws and the way they're being interpreted in light of COVID-19 is also something that's evolving at pace. So please do keep your eye on the news, the sort of government guidelines, etc. And then just to give you a few further resources as promised, I would first of all recommend most highly the ACAS website, because as we say, this is what employment tribunals will be firstly looking towards to substantiate any claim or any decision they come to. They're going to be looking to ACAS's standards and whether the ACAS code of practice has been followed by your employer and by yourself, that both have acted reasonably and fairly and proportionately, and that indeed this will be the basis which will indeed will be kind of underlying their decision. And a phenomenal resource is the ACAS helpline telephone number. And if we're not able to answer all your questions today, or you're not able to sort of, even get help, you don't have access to a lawyer or whatever else to help you, the ACAS helpline are brilliant. They are employment lawyers who are there on standby for the price of a local call, who will help you in whatever situation you're facing. Just explain it to them, explain your situation, and indeed, what your concerns are. They will let you know what the law is. They'll let you know what your next steps are and what you need to do. The ACAS website always also provides you with sort of information, for example, on disciplinary and grievance processes. And if you sort of want to be able to indeed have a look at, what to expect with those, you could just go to the website. The Labour Relations Agency is equivalent of ACAS in Northern Ireland. And then there's also the Citizens Advice Bureau. Oops, I think I just locked myself out there. And okay. Oh, right. I think I've stopped sharing, have I?
You're still sharing.
Oh, right. Okay. Right. Okay. I don't know what's just happened there. I think I clicked the link and it's kicked me out. Okay. Let me see if I can get back in. You see. Yeah. Am I still sharing? Sorry.
Yes, you are.
Yes.
Yeah.
See that? Okay. And so the next would be also the gov.uk website for information on employment and employment law related topics. The Lawworks website is also great as well. There's sort of various lawyers that they can connect you to for free legal advice, and law centres advice as well. A lot of these are running online, yes, and also via telephone now because of the COVID situation. So you don't have to sort of wait for a face-to-face appointment. So I take advantage of that as well if you are looking for advice and help. So that's the end for me. I'll pass back over to Pastor Kavaloh or to his team to continue.
Right. So, yeah, good. What can I say? Thank you very much indeed for such an informative presentation, both to Pastor Kavaloh and to Ayomi. I think our chat now is open. So within the last few minutes, we have about, 10, 15 minutes for questions. I know that you have been given a lot of information, but if you still have any questions, please take this opportunity now to ask them. Can the slides be available? That's one question. Are the slides available? Pastor, will the slides be available? Or
possibly by
Mr. Ayomi, if you're muted at the moment.
Am I?
No, Ayomi.
No. I was speaking to Ayomi. If you can unmute yourself, we can't hear you because I can see you saying something.
I think Pastor was
Good stuff.
answering the question, I think.
All right. They will be available by personal request to Ayomi and myself. We don't want these slides to fall in the hands of someone who may not fully understand, and they are misinterpreted. Then it will defeat the whole object of our presentation. I can't rule out their availability, but it must be by personal contact, and we will talk between us and Ayomi what we can and what we cannot. Nothing to hide. But we must be wise as serpents, remaining harmless as doves.
Okay.
Can I also just add? Somebody else did ask me the same question, and I just stated that on the YouTube channel, this information, the whole presentation will be there because it's being recorded. So if you're worried and you're thinking you'd like to see that information, then you by all means you can go onto the YouTube channel and replay this, which personally I think is even better because then you get to hear the presenters explaining each point rather than you having the slides and sometimes misinterpreting them, and God forbid that you end up using them in a different context, and there's some kind of misunderstanding.
I think that's a good idea to refer them to our YouTube to follow through, because they can see the slides, playback, backwards and forwards, but certainly will be available. We don't want to leave a closed door as such, but we will have to decide who we are communicating with and your purpose. It's not just a matter of forward. If you take these slides and forward to someone who may not fully appreciate, then you can appreciate the offset and damage that this well-intended presentation was meant to fulfill.
Okay, so yeah, we've been told that they're going to be on YouTube. That's right. Alex, has anybody on who was listening on YouTube, do they have any questions?
Just give me a second. And there are no questions at the moment on YouTube.
Okay.
I have to commend Sister Ayomi, because I think she preempted quite a few of these questions. So they were conclusively answered, I think, and they were the very questions that some of us had for ourselves anyway. But yeah, on YouTube, there's no questions at the moment.
Okay. I'm just having a... Well, there's some commendations. It says, praise God for a very in-depth presentation, Pastor Kavaloh and Sister Ayomi. Very informative. God bless you both. All right. I mean, with regards to sort of time limits and taking cases to an employment tribunal, if you're going to use the Equality Act 2010, do you have to be working for an employer for 2 years?
Ayomi,
No, so discrimination, which is will fall under the Equality Act 2010, is a day one right. So as soon as you walk into an organisation, if they sort of treat you unfairly, based on what we discussed here today, that from day one you can claim that, and that is something that's protected by law from day one. It's only constructive unfair dismissal and unfair dismissal, which requires you to have 2 years service within your organisation first before you're able to claim for either of those.
Okay, thank you. If you're self-employed and choose not to be vaccinated, but the question isn't finished, so I'm just wondering if they're thinking that whether or not the legislation will apply. I'm not quite sure. No, the question wasn't finished, so I'm not quite sure what they were trying to say. How easy is it to win constructive unfair dismissal cases?
That's a very good question, because it's actually, and this is something which is probably quite important actually to say, is that it's harder to win a constructive case because you've actually resigned. You felt forced to resign, but you've resigned. That was your choice still. And in a situation like this, I would advise everybody to, don't maybe know how to say it in the right way, but it's better to put your employer in a position to almost force their hand, if you like. So it's better to let them dismiss you. So, and then claim unfair dismissal. Let them go through the process, do whatever they want to do. And at the end of it, if they dismiss you, then indeed say, well, you could say, well, look, I'm in this situation. I've been dismissed unfairly by my employer. They haven't followed a reasonable process. They dismissed me for an unfair reason, which could be the discrimination. And that is a better way to go than to take yourself out of the picture and resign, and then try to sort of, if you like, to contend with this situation from a situation where you've taken yourself out of it. It's kind of more of an uphill battle. It's still effective. And if you have good reason, like discrimination, you'd still be in a very powerful position to be able to indeed to be successful. but you've taken yourself out of the game. So it just makes it a little bit harder to indeed to see what maybe could have happened as well, because sometimes maybe your employer may have just settled with you, or maybe they would have changed policies. So if you've taken yourself out, it kind of makes things a little bit more difficult. So I would say, if possible, try to go with the unfair. Try to let them fire you if need be. If they say, well, you have to have the vaccine, say, well, I can't, and give your good reasons, which are fair and reasonable. Follow a good and fair, upright, reasonable process. And then after that, if they decide to dismiss you, go with an unfair dismissal if you can, rather than constructive unfair dismissal, if that makes sense.
Yeah, thank you. So somebody says, thank you both. All praise be to God for all, for all that was shared. And I can see that it's important that we do not fear. We do need to put our trust in God, for he alone can see us through. Thank you for that. Right, here we go. So if you're self-employed and choose not to be vaccinated, you can still have customers. Can you still have customers? Can the government force you to be vaccinated?
At this juncture, we repeat, it will be unlawful to force anyone. First of all, you are self-employed. Unless those you are working for demand, say you are a plumber or a gardener, there may be those who wouldn't mind you coming as long as you have your face mask and social distancing. But there may be those who will insist that you be vaccinated. Even then, that must be your choice. Good that you're self-employed. And the point of being forced to be vaccinated, unless, and I'll be shrewd to say this, you can only be forced to be vaccinated if you are incapacitated, you're suffering from dementia, you can't think for yourself. Someone may have to act on your behalf, an attorney. If you are mentally ill, you may be an adult in your 40s, 50s, but you are mentally ill, there may be some intervention, a minor. But if you are not, if you will be forced, it will mean that the whole country, the whole population must claim it is mentally sick. If the whole of UK decide now we are all mentally sick, then we can all be forced to be vaccinated. But if there will be some who don't belong to this category, I have my mind still, I work for myself, you cannot and must not. I can't talk about tomorrow and the day after. The whole thing is dynamic. Don't be surprised from which angle issues will be coming. But as from 23rd of May, right now, it will be unlawful. As Dawkins said, Dawkins, we referred to earlier. Even if your end view is plausible, but guess what? If we all get vaccinated, there will be less hospitalized, death will be lessened. That is not a legal reason to be vaccinated. Very powerful. Unless that state backs it with a law that is legitimate. You can't say, oh, guess what? If we all get vaccinated, we'll go back to the football match, we'll all go back to to our restaurants, and we'll be back to normal. That end view is important, but must be backed with sound, legitimate legislation. At the moment, legislation says no. So whoever is asking the question, it will not apply to you. If it applies to you, someone has a case to answer, period.
Okay, right. So I I'm just looking at the time. This is going to be the last question because it's coming up to 6 o'clock. So will it not be a question or a problem if someone works in a place where the majority of employees have taken the jab and then that person chooses not to take it? So will that be an issue?
Yomi?
Majority versus the minority.
No, that won't be an issue. The only issue that will be at stake is your reason for why you are not taking it. So this has nothing to do with anybody else's decisions. It will just come down to your own, and yours will have to be defensible. Your reason for not taking it will have to be shown to be defensible on the grounds as well of what is fair and what is reasonable. So if you're saying it's for religious reasons, and that is something that is protected, as we said, by the Equality Act 2010, if it's because you have a medical exemption, that is also protected. If it's because you have a disability, that is also protected by law. But as long as you have a good reason, it doesn't matter if everybody else doesn't agree with you or thinks differently to you. You are able to be able to indeed claim, as long as you just have something that indeed is legally defensible at the time.
Possibly, if you don't mind, I may add to that. Is out there now that a case like that, the onus is not so much on the employee, but the employer, who must prove that the action is a legitimate aim. That's where the proportionality comes in, the balancing act. If that ends in court, what the judge is going to look into is, was there any discrimination on the provision that the employer provided? And the employer must prove there wasn't. And possibly, if I may say that the court, what the court is going to do, it won't be for everyone, but the judge will take each case in its own merit, the facts and the circumstances surrounding your case. So it can either go your way on proportionality, it can go against way on the, this word is fluid at the moment. It can tip this way or that way. No wonder Ayomi and myself can't tell you win or you don't win. As Barrister Louis said, reasonableness, proportionality, necessary. There can be subjective terms because the state of mind, well, to me, is proportionate. But can that stand the test of scrutiny being an objective, justified reason for the employer to do what he did? Even if you're all by yourself, could that employer, when it comes to proportionality, it must mean that it must be balanced. It can't be because you are the only one against many. Well, could the employer have taken into consideration deploying you in a certain way to still keep you? Was everything done to keep you? Or did you just, oh, he's in the minority, off you go? The judge will look into that. It could be indirect discrimination. Mm-hmm. I don't know, you may want to add something, Ayomi.
Yeah, I think you summarized it really well, actually, in terms of the way it works out. Just something, I know that time is going, so I just wanted to add in something, if that's okay, just to quickly add. I know that as well, that potentially as well, people may have already resigned, or people may be in situations where, they currently are maybe dismissed or facing these situations or wondering what to do. And even if you have resigned right now, to be able to indeed lodge a claim with the employment tribunal, you have 3 months less 1 day. So that's 3 months less 1 day to be able to indeed go through, even after you've resigned, this is, or you were fired or whatever happened, you have 3 months less 1 day to be able to indeed actually put forward a claim to an employment tribunal based on the situation that you faced. So even if you've actually, I know some people have actually resigned or they felt they've lost their jobs because they were bullied into it by their employer and they've just resigned. Even if you sort of, 2 weeks later, you're thinking, oh no, I just can't believe it. You can still now, as long as 3 months haven't passed since your dismissal or your resignation, you can still put in a claim to an employment tribunal for whatever it is that you're seeking. At the time, it could be to be reinstated so that indeed your employer could redeploy you in the organization if you can't go back to your previous job, or indeed it might just be to clear your name or whatever it may be, whatever your reasons are, and clear your record as well from dismissal. You have 3 months after the after whatever may have, if indeed for some people who may have actually left their organization already, you can still actually sort of be reinstated if it's come to a dismissal situation and you haven't known what to do. So just to sort of add as well, that's just a something further to think about.
Mm-hmm. Okay, so thank you very much. We've come to the end of Q&A, so I'm going to pass over to Alex.
Okay, thank you, Sonia. Once again, thank you very much, Sister Ayomi and Pastor Kavaloh. I just want to float an idea out there, because there's some people in the chat that have asked for both your email addresses, because they want to speak to you about specific circumstances pertaining to them, and they obviously don't want to put them up on the chat. So that's one issue that people have asked for. Well, I don't know whether it's possibly within the chat. Yes,
I've posted an email address, so if anybody wants to contact, there is an email address that we've posted on there, so that you can send. I'm just looking for it actually, so we could.
I've got it here.
Oh, you've got
I've got it here,
yeah.
Sonia. It's
okay.
mail@adventrlp.com. So if you look in the chat, mail@adventrlp.com is the email that you can send any questions to. And that what I was actually about to say was perhaps it's best that if you have specific questions, that you obviously don't put them in there within this, you don't put them within the chat, but send an email to mail@adventrlp.com specifically asking for Pastor Kavaloh and Sister Ayomi to respond to your issues, and then they can then respond to you, and then you can begin that conversation between yourselves and them. So that's one thing. But the other idea that was in my mind, I was just thinking that perhaps there are people that are beginning to, having seen the presentations, that questions are beginning to arise in their minds. So might it be prudent to get people to send those questions to mail@adventrlp.com and request responses anyway, general responses? Perhaps if there were, quite a few questions, then we might, I don't know what you think, the presenters, but we potentially may have to approach these issues in another presentation at a later date. And then,
sooner than later.
At least
Sooner than later.
Sooner rather than later, definitely. Sooner rather than later. So if you're okay with that, then yes, we're just putting it out there that please send your emails to your questions to mail@adventrlp.com. And those of you who have requested Pastor Kavaloh's, who would like to speak to Pastor Kavaloh and Sister Ayomi, then please do send that information specifically saying that, look, this is something that I want to talk about only with them. And then
sure.
you will be contacted.
Okay,
and once again, anybody who...
If I should ask very quickly, Elder, the entire team, I'm talking to the audience, including Ayomi, we may not have all the answers, and we don't claim to be, but we can't just bury our heads in the sand and really be suffering in silence as if no one is out there. This pains us. You are not coming because we have the answers, but don't suffer in silence. that would be a shame cast on my church. You as members have done a lot to this church. You deserve a listen. We don't have answers, but you deserve a listening here at this critical time. Nobody knows tomorrow and the day after, but we must be there for each other. We've had enough tears in the past few weeks.
Amen. Thank you. So at this point, I think I'd like to have a closing prayer. I don't know whether my brother from Hackney, Elder Darrell, is about. If you're available, Elder Darrell, if you're not available, if he's not around, I'd like to ask somebody who did ask a question. If you don't mind me pointing you out, but Elder Phillips, I think you're still on there.
That's Darrell, I think.
Well, I didn't know which one. I was thinking that was Darrell, but I wasn't too sure. Okay, they're not available. Okay, I'll tell you what, Sonia, if you don't mind, if you can close this off with a word of prayer. But before you do, I just want to once again thank you so much, both of you, Pastor Kavaloh and Ayomi. You've just had fantastic presentations, and I urge everybody to pay attention to what's going on. Look at the emails that are coming in from the adverts and the flyers that are coming through the SEC mail, etc., and Adventrlp, because this information that we have it's so valuable. People pay money sometimes just to get this kind of information. So we're indeed blessed to have presenters like these who can take their time to come in and to share with us such crucial information. Thank you once again, and thank you, Sonia. Thank you, Elder Eric in the background, and thank everyone. I just want to thank every one of you who's been able to log in and to come in and just to listen into these wonderful, this information that's so crucial and so important for us. Sonia, if you can pray for us, please.
Our Father in heaven, we want to give you the thanks, give you the glory, the honor, and the praise. We thank you, Lord, for Pastor Kavaloh and for Ayomi for the presentation where we have been enlightened with regards to what our rights are. And Lord, we recognize that we are living in the closing pages of this earth's history where things will not get any better. But Lord, we want to thank you for the promise of your word, full of promises for us, where you tell us not to be frightened or fearful of the future, as long as we put our hope, our trust, and our strength in you. You, Lord, will carry us through any situation that we have to go through. Lord, you have told us in your word that we must stand up for you. For when we stand for you, you will stand up for us. So Lord, help us not to be fearful. You have not given us the spirit of fear, but of power, of love, and a sound mind. So Lord, as we close this session, please continue to abide with us, to bless us and keep us in your love and in your care. For you are a loving, kind, and compassionate Father. We have no one else that we can come to but you. So be with us, I pray, in the mighty, the precious, the wonderful,